What intellectual property protects iconic cartoon characters? Imagine a character so well known that people instantly recognize it just by its shape or colors. That kind of recognition doesn't happen by accident. It's protected by specific laws that keep the character's identity safe. When it comes to protecting these characters, two main types of intellectual property come into play: trademark law and copyright law. Each plays a different but important role in keeping the character safe and exclusive. Trademark protection is all about the character acting as a badge of origin. If a cartoon character is used on products or advertising to show where they come from, it can be registered as a trademark. To qualify, the character must be distinctive and easily recognized as representing a particular brand or company. For example, if a character is used as a logo on merchandise, it can be protected as a trademark. This means no one else can use a similar character in a way that might confuse consumers about who made the product. Trademark rights cover the character's name, visual design, and unique features that identify the brand. These rights help prevent others from copying the character or using it in a way that could weaken the brand's identity. Registering a trademark requires showing that the character is used in commerce, meaning it appears on products or in advertising. It's also important that the character is distinctive enough to stand out. Sometimes, minor changes to the design might still keep the trademark rights, but if the character becomes too common or generic, protection can be harder to maintain. Copyright protection, on the other hand, is about the creative expression of the character. It covers how the character looks, its personality traits, and the stories it appears in. Copyright doesn't require the character to be used as a brand or logo. Instead, it protects the original artwork and storytelling that make the character unique. This means that copying the character's visual design or creating derivative works without permission is illegal. Courts have recognized that cartoon characters are protectable as original artistic works, not just ideas. So, if someone copies the character's appearance or personality traits, they could be infringing on copyright. This protection applies to the character's depiction in cartoons, comics, movies, and other media. Many famous characters are protected by both copyright and trademark law. For example, a character's visual design might be copyrighted, while its name and logo are protected as trademarks. This layered approach helps rights holders control how the character is used and prevent others from copying or imitating it. They can also license the character for merchandise, movies, or other uses, making sure it stays unique and recognizable. In summary, iconic cartoon characters are protected by trademark law when they serve as brand identifiers, and by copyright law as original creative works. Both protections work together to keep the character's identity safe, prevent unauthorized use, and support commercial opportunities. This dual protection helps ensure that the character remains a recognizable symbol and a valuable asset for the brand or company that owns it.